that you drive, I will have a contempt hearing. You'll be facing an additional 6 months of jail and a $500 fine every time your happy-go-lucky butt gets into a car. I don't care what your excuse is. You cannot justify getting into a car and driving for any reason whatsoever. Do you understand?
Yes, sir.
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On September 2nd, 2024, officers were dispatched to a possible intoxicated driver that crashed into the business at Jack in the Box. Defendant's vehicle was stopped in a parking space near the roadway. The vehicle had the engine on and the transmission was in reverse. The defendant was passed out behind the wheel. The officer put the transmission in park and attempted to wake the defendant verbally. And then after physically trying to wake him up, after waking up, the defendant pressed the gas pedal, causing the engine to rev up, then pressed the brake and gas pedals simultaneously. The officers observed red, watery eyes, slow, slurred speech, and a strong odor of an intoxicating beverage. The defendant immediately became belligerent and hostile with the officers when the officers attempted to have him exit the vehicle and detain him. The defendant was resisting and tackled one of the officers to the ground and then kicked him. The officer read the defendant his Miranda rights. The defendant stated, "I don't answer questions." The defendant attempted to spit on the officers throughout the contact. Due to the defendant's resistive state, standard field sobriety tests could not be conducted. The DIC was read and the defendant refused to provide any specimen. A blood sample warrant was also issued.
I see that you did pick up 2 felony assault of a peace officers. What other criminal history does he have, please, Ms. Davis?
Your Honor, he has a interference in July, then a DWI in 2022.
I mean, anything out of Harris County? Is it all just Harris County?
No, sir.
It's all just here?
Judge, there was a DWI out of Galveston in 2018, but it was dismissed.
Ms. Jabbar, I'm taking away your privilege to drive. You were not allowed to drive whatsoever. You will be signing an affidavit with me today promising me you're not going to drive, and if I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months of jail and a $500 fine every time your happy-go-lucky butt gets into a car. I don't care what your excuse is. You cannot justify getting into a car and driving for any reason whatsoever. Do you understand?
Yes, sir.
You will be required to obtain a handheld interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. But I'm going to put a monitor on your ankle so I know that we're doing it the right way and that you're not going to skip tests.
Yes, sir.
This thing must be charged on a daily basis. If the battery dies, so do you. I will put you in jail and I'm going to make your bond in the felony amount. Do you understand?
Yes, sir.
What do you do for a living, sir?
I'm a pipe fitter.
What are your hours of operation?
What's that? My
What hours do you work?
I'm working night shift right now. I'm working night shift.
I'm putting a curfew on you. I don't want you out in the middle of the night.
I'm gonna be at work. The other judge told me I'm supposed to get a GPS. I'm gonna go do all that stuff right now.
Say it again.
The other judge from jail, he told me to get a GPS.
Yeah.
And
I don't want you out in the middle of the night.
he said,
This is three DWIs, 2 assault of peace officers. You just got done with an interference and another eluding from a peace officer. You just pled to a DWI. This is 4 DWIs you have. You are not allowed out in the middle of the night. Do you understand?
sir,
Your curfew will be from 9 p.m. to 6 a.m. in the morning. What I would advise you.
As the proceedings unfold, Judge Fleischer delivers a stern and emotional warning that underscores the seriousness of the defendant's repeated conduct. Prosecutors detail a chaotic arrest in which officers allegedly found the defendant passed out inside a running vehicle after crashing into a local business, creating an extremely dangerous situation that could have ended far worse. When officers attempted to take him into custody, the encounter reportedly escalated rapidly, with the defendant becoming combative, resisting arrest, tackling an officer, and attempting to spit on law enforcement personnel. The courtroom atmosphere grows increasingly tense as the judge reviews the defendant's troubling criminal history, which includes multiple prior DWIs and felony assaults on peace officers. Clearly frustrated by what he sees as a continued disregard for both the law and public safety, Judge Fleischer stresses that the court cannot continue allowing the same reckless cycle to repeat itself. The judge then lays out a series of strict bond conditions that leave absolutely no room for excuses or mistakes. The defendant is ordered not to drive under any circumstances, must obey a nightly curfew, and is required to submit to continuous alcohol monitoring through both a handheld device and an ankle monitor. Judge Fleischer repeatedly emphasizes that even a single failed alcohol test, missed check-in, curfew violation, or unauthorized trip behind the wheel will immediately result in his bond being revoked and a return to jail. The hearing serves as a powerful example of how courts handle repeat DWI offenders whose actions are viewed as an ongoing threat to the community, with the judge making it clear that public safety now outweighs any further leniency.
What you to do is go to your job and do whatever you can to start working the day shift, because I'm not allowing you out in the middle of the night. And if I find that you out, there's only one place that you're going to go. Do you understand?
Yes, sir.
I'm also ordering you not to have any contact with the officers in these cases as well. I will waive the fee for you as far as the scram device is concerned, and I want you to really appreciate that, because if I didn't waive the fee for you, you would be on the hook for about $400 to $500 a month on that thing.
Thank you.
You will be required to hire your own lawyer. So we're going to reset your case to give you time to hire a lawyer, but I would get on it quick. Do you understand?
Yes, sir.
You have 1 day to get the GPS monitor and the ankle monitor as well for alcohol. You consume any alcohol whatsoever. And I'm telling you, I will notate everything that we're going here, so that if you try to come here and tell me the excuse that you're consuming mouthwash, you have any problems whatsoever, you ate a piece of cake and it had alcohol in it. Any alcohol that's in your body, you will go to jail. I'm going to have you come up here, swear to us that you're not going to drive. After that, I'll get you to Victoria, where you will sign a reset, and then you will get with pretrial for your bond conditions. After that, we'll let you go. You are on a very short leash, Mr. Garcia Ibarra. You're out there in the free world now. You better really make some better decisions, because if not, I'm going to do everything in my power to protect the public for every single person who is a danger. Do you understand?
Yes, sir.
It's high time that you get it. With all these DWIs and assaults, I'm done with it.
As the hearing comes to a close, Judge Fleischer delivers a powerful final warning that leaves little doubt about the seriousness of the situation. Looking directly at the defendant, the judge makes it clear that the court is no longer willing to take chances after years of repeated arrests, alcohol-related offenses, and violent confrontations with law enforcement. The atmosphere inside the courtroom remains tense as the defendant is reminded that every single bond condition will be strictly enforced, with absolutely no tolerance for excuses, missed check-ins, failed alcohol tests, curfew violations, or any attempt to get behind the wheel again. Judge Fleischer stresses that the purpose of these restrictions is not only to monitor the defendant, but to protect the public from what the court views as an ongoing danger created by repeated reckless behavior. The hearing ultimately becomes more than just another routine arraignment. It serves as a stark example of how quickly repeated poor decisions can escalate into life-changing legal consequences. Throughout the proceeding, the judge repeatedly references the defendant's lengthy criminal history and prior opportunities to change course, making it clear that the patience of the court has nearly run out. By the end, the message from the bench is unmistakable. This may be the defendant's final chance to prove he can follow the law while awaiting trial. If he fails, the consequences will be immediate and severe. The dramatic courtroom exchange leaves viewers with a clear picture of the growing challenges courts face when dealing with repeat DWI offenders, balancing rehabilitation, accountability, and the urgent need to keep the community safe.